Alex here with part 144 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that it will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We move into my reply to opposition to motion to modify custody. This is in response to my ex's attorney's opposition to the modification of custody. At this point in time, the same judge is still on this specific case. I've been getting some questions about that. Just remember that the timelines aren't necessarily in sync in each of the different cases. But yes, in CV 13-01019, the new judge is taken over. In FV 08-03200, this judge is still on. The first judge is still on this case. My mindset at the time was, for the most part, I would say pretty positive, because nothing in my ex's opposition surprised me. It was surprising to see that those defenses would be raised in the sort of sense of a moral person who hasn't gone through the litigation process. But having gone through the litigation process, it was for the most part everything that I expected to see from my ex and her attorney. So when I went into preparing my reply, I do recall being pretty optimistic about the whole situation, because for the most part, everything was within this sort of controlled sphere. Everything was within what I had anticipated, and I had hoped that everything would lead to a modification of physical custody, and it in fact did. But I don't think I can really go much more into any of that aside from actually taking a look at what I have filed. Here we have my reply to opposition to motion to modify custody. Going into the standard introductory paragraph, I identify myself to the court as the father, indicate that I am representing myself, appearing in proper person, and that I have filed a reply to my ex's opposition to my motion to modify child custody, and that my reply is based on pretty standard language there, points and authorities. Let's see. First, I address my ex's McMonigal assertion. This is case law that is, for the most part, consistent with res judicata principles. I don't think at this point in time that I knew that I didn't have to change the circumstances. So let's take a very quick look at my response to McMonigal. I am quoting my ex's attorney's statement that the events which are not barred from consideration are those that took place after February 8th, 2013. And then I say this is not the law under McMonigal, events that took place. And look how this attorney leaves out important language. It doesn't say that in McMonigal all events that took place are precluded. It says very specifically, and I bold this, that the only portions that are inadmissible are those that you are trying to use to establish a change of circumstances. Again, this is not required in Nevada based on the statutes that exist in the law today. Anyway, this whole thing is a complete and total waste of time. It's not consistent with actual controlling law. But even if we were going to say that McMonigal applied, it would only preclude bringing evidence that would be used to establish a change of circumstances if it was from before that date. And I think I mention the prongs. So I go into the next section here. I state that the change circumstances prong is based on principles of res judicata. By the way, I have a video on that topic, and prevents people dissatisfied with custody decrees from filing immediate, repetitive, etc. The events that occurred before February 8, 2013 are not precluded entirely from consideration. They are only precluded from consideration in the threshold question of whether or not a change of circumstances has been established. Once you establish a change of circumstances, the question becomes whether or not the child's welfare would be substantially enhanced by the change. And at that point, yes, you can use everything, even the stuff that's been brought up before that date. So my ex's attorney is completely wrong on two different counts. The first count is, number one, this doesn't even apply. This is a change of this is a change of custody in a joint physical custody situation, and you don't have to show a change of circumstances at all. So this is a complete and total waste of time. It's completely wrong. Number two, even if this was required, even if I did have to show a change of circumstances, she's wrong again, because I only am barred from showing actions prior to that date for the first question, the threshold question. Once you get past the threshold question and you get to the best interest question, at that point in time, anything can be used, and it makes sense. It's logical. What she's saying is highly illogical, and I go into why that's highly illogical in the rest of this paragraph. Next assertion here is that the change of circumstances that warrants modification in this case is not flimsy, as my ex contends. The significance of dental hygiene is illustrated by the fact that this child has had 5 crowns installed and 2 molars extracted. And then there's 2 other teeth that just fell out because they were so rotted. So all of this damage has occurred, and this would show a change of circumstances. And then I spent some time here going into the teacher's assertions, which, with regards to the behaviors at school. Of course, this is not as strong. This is pretty, still pretty strong evidence, but the severe dental decay to the point of near infection was much, much more damning evidence, in my opinion. Okay, next assertion here is that a prima facie case has been established, and therefore I have shown adequate cause for a hearing. Oh, I love this part here. In the first sentence, I immediately attack my ex's attorney's assertion that I have built my case on the basis of hearsay. The purpose of my allegations, which are supported by affidavit and relevant authority, is to establish a prima facie case, not the entire case. The briefs alone cannot lead to a modification of custody. Rather, they are analyzed to determine whether or not, quote, adequate cause, unquote, for a hearing arises. And the Supreme Court of Nevada explains this in Rooney. So for the third time, this attorney is flat wrong. She's not even close to the realm of reality. So she's way off on res judicata. She's way off on change of circumstances. She's way off on adequate cause for a hearing. She's not even, this is something that I think alarms a lot of people, to think that their opponent's attorney would make assertions that aren't even close to true. But this happens all the time. And this happens because of what I talk about in the video. Win at all costs lawyering, and they also exploit what I talk about in the video, self-representation bias. So in this portion, I explain that I'm not building a case on hearsay because we aren't even at the hearing yet. How can you get into hearsay if you're not even at the hearing yet? All you are doing at this point in time through the briefs is telling the court that this is what I am going to prove when we get to the hearing. This is an offer of proof. I am telling the court what I intend to show the court. And how do I do that? By bringing the witness in to testify on the stand, not by showing the court a bunch of letters and paperwork, stuff like that. That would count as hearsay. That would not be allowed. I talk about why that would not be allowed in the video, hearsay, but keep in mind that that's specific to Nevada. Watch that video. Don't just skip over it, because in that video I explained that in other states there are exceptions to the hearsay statute, including exceptions that apply to family law. And in those states, you can use letters. So I'm not going to go into that now because I have another video that's dedicated to that topic, and go ahead and move on into the next section. I explain how the court is going to actually take the testimony on the stand, weigh the credibility of the witnesses, etc. We're going to go into the next section here. Likewise, my ex's citations to email demonstrating purported, quote, communication with Mrs. Williams, unquote, cooperation and sincerity do not per se establish her version of events either. Just like I have to do, so does my ex have to do. She can't use paperwork to win the case. Neither can I. All we can do is use the paperwork to actually get the hearing. Once we have the hearing, she needs to show through examination of her own witness, through cross-examination of my witnesses, that what she is asserting with regards to the communication between herself and the teacher is actually what's going on. So here I am using against her her very own assertions of hearsay. I don't know why she's using that word. It makes her look like a really bad attorney, in my opinion. If I saw an attorney say something like that, I would think something's wrong. I'm not going to hire them. Next assertion here is that I take this opportunity to deny failing to give my ex our son's homework. The referenced email attached as Exhibit 6 does not reveal, quote unquote, or confirm this allegation in any way. It's just an email from my ex to the teacher. It's possible that my ex lost the homework or that the child misplaced it. Also, my ex fails to reference where I, quote, accuse her of not providing the child's tracker, unquote. This is just communications between my ex and the teacher. This is not even relevant to what's going on in this case. It's just like she took some random piece of paper, stuck it to the motion, and said, look, based on this, don't read it, judge, just trust me. Based on this, this is what's actually going on in this case. And then, of course, I went ahead and took a look at Exhibit 16, and I found out that it had nothing to do with what she was asserting. Next, we have the litigiousness and harassment section. I have explained this repeatedly on my channel. The Supreme Court of Nevada has explained this repeatedly, and they have overturned decision after decision after decision where the judges don't listen to the fact that the filings in and of themselves, the number of filings, do not per se constitute harassment. In Jordan v. State of Department of Motor Vehicles, the Supreme Court of Nevada distinguishes between litigiousness and an intent to harass. They are two different things. This is obvious, but there are attorneys who will exploit the fact that judges don't look into these details. They use it as a weapon. They induce the judge into committing legal error, and they just cross their fingers and hope that the litigant doesn't know how to file an appeal, which many litigants don't. In this particular case, all my ex has argued is that I am litigious. Litigiousness is not automatically harassment. You have to look at the number, not the number, sorry. You have to look at the contents of the filings, not just the number of the filings, and determine whether, based on the contents themselves, that the things that are being brought up in that paperwork is just intended to harass or it's brought without a reasonable basis. If you just look at the litigiousness in and of itself and you use that as a basis, you are going to get overturned on appeal if that litigant knows how to file an appeal. She cites here 41 orders that the court has entered. Who cares? Who cares how many court orders have been entered in the case? You have to look into why those court orders were entered. You can't just say based on number 41, I guess there's some magic to that number, I win and he is harassing. It doesn't work that way. Try it. It won't work if you take it up on appeal. The judge will get dinged on appeal. Going into the next section here, I am not attaching the police reports to embarrass my ex as she asserts. Rather, I'm attaching the police reports because it is consistent with Nevada Revised Statute 125.480 subsection 4F. They have held in the legislature that the mental health of the parents is relevant to determining the best interest of the child. So, if you aren't going to listen to logic and reason, you're going to listen to because the law said so. I repeatedly file the police reports regarding my ex's attempted suicide because the law said so. It's always going to be the stronger argument. If you get sucked into trying to explain yourself away, all you're going to do is waste a bunch of time, and you may potentially fall into the trap of the attorney in this case. This attorney is trying to get me to explain in some non-legal sense why I continue to use a police report. I'm not going to do that. I'm not going to fall for that nonsense. I use a police report because NRS 125.480, done. Move on. And then there's also NRS 48.025, which says relevant evidence is generally admissible. And then there's also NRS 48.015 that says evidence is relevant if it has any tendency to make the existence of a fact more or less probable. I am asserting that 125.480 subsection 4F applies, and I'm using the police report to buttress that statement. Next assertion here is that I am a big advocate of joint physical custody, and from the case's inception, I sought a joint physical custody relationship. You can look at the petition to establish custody. You'll see that that is exactly what I did. You can also take a look at the affidavit of Laura Turner, which talks about the dangers of our son being ejected from school. You can also take a look at the trial statement where I withdrew my request for modification. If I'm such an evil, vindictive parent, why did I withdraw my request? You can also take a look at the motion to modify child custody, where I go into a litany of issues that my ex continues to cause to occur that continues to damage our son. It's just another assertion of nonsense from my ex's attorney that's not anywhere near the realm of reality. This is starting to make it clear to me why she retreats from this case. As I read this reply to opposition to motion, I start to realize just why this attorney just took off running. You will see the motion to withdraw pop up in this case very soon, and we'll talk about that more when it happens. The last thing that I bring up here is the affidavits of the kindergarten teacher and the dental hygienist, two more experts that have to explain to this court why intervention is required. This is the kind of stuff that it takes to get through the thick skull of some of these judges. Not one, not two, not three, not four. I don't know how many affidavits I have to file. I don't know how many teeth have to fall out of a skull. I don't know how much pain a child has to go in before the court will actually wake up and do its job. And that's what I'm trying to do here with this reply to opposition to motion. I'm basically dismantling my ex's case thoroughly. Let's go into the next assertion here. I've also recognized that my ex has an attorney, and I respected the fact that she had an attorney by granting her more than a dozen extensions. That's not the conduct of a litigant who wants to frustrate and harass their adversary in ways that inflate their attorney fees. Had I wanted to do so, I would belligerently refuse to grant my ex's counsel any leeway, thus forcing her to file more motions. And how does the court respond to this? Both judges, the first judge and the second judge, file orders trying to get me to pay attorney fees. That is how little the court cares about actually looking into the history of the case. The first judge, I was able to bring down in price substantially. Something like a 70% discount is what I secured, and that would have triggered an appeal had he not allowed that. The second judge just flat out took to the Supreme Court and they just overturned her decision. They said that she abused her discretion. It's really unfortunate that judges don't look into this, but you really have to look at this kind of assertion as one of those that you're going to have to really take them to the cleaners on it if they rule against you. Too many judges do not care how good of a parent you are being, how much effort you're trying to undertake to keep those attorney fees down for your ex. They need to really be taken to school by the Supreme Court. So keep in mind, not only do you have to show the court through your actions that you are not trying to raise your ex's attorney fees, you also have to really prepare yourself for appeal, because most likely you're going to do the right thing and the judge is going to do the wrong thing. And that's just because of what I talk about in the video, self-representation bias. It is just too easy for them to dupe the court into believing that you're just like all the other self-represented people. And so you're usually going to have to jar the court. You're going to have to shake them awake. And that usually occurs, unfortunately, in the form of an order reversing and remanding. Going into the next section here, we have corporal punishment and the parental privilege. There's a pretty cool piece of common law that I found when I was looking through Nevada case law. My ex is trying to use CPS to show that everything that she's doing is justified and A-OK. I think I've already dealt with the problem of preclusion not applying. What I'm going into now is whether or not my ex is allowed to use that form of discipline. Let's take a look here. Where does that come up? Okay, here we go. So a number of states have codified the parental privilege defense, and they're trying to say that to a certain extent, there is some damage you can commit to a child that is protected under parental privilege. And they explain this in the case Willis v. State. However, Nevada hasn't done this. And since Nevada has not done this, then the privilege exists instead by virtue of common law. Under the common law, the privilege is lost at the point at which a parent ceases to act in good faith and when the parental affection, and with parental affection, and instead acts immoderately, cruelly, or mercilessly, and with the malicious desire to inflict pain. So if you can show that this has occurred, then your ex loses the parental privilege, and then they can be dinged in whatever way the court deems necessary on modification of custody, contempt of court, criminal charges, etc. Some states probably do have statutes that have codified how you can use a parental privilege defense. In those states, you would not be relying upon the common law. Instead, you would rely upon the statutes that state has created. Next assertion here. Despite my ex's contentions, Exhibit 1 of my motion does not conclusively establish that the CPS reports are unsubstantiated. It states a conclusion without offering any particular basis, details, or circumstances. The teacher has reported receiving a call back from CPS stating that no investigation could be conducted because my ex could not be located. Considering that my ex is a fictitious address until recently, this is more than probable. It is in the best interest of our son to inquire into these reports. My ex has not claimed privilege to the information. That's NRS 49.015, and we have NRS 48.025 to counteract what she's trying to do. If you want to block evidence from being considered, you have to show it's privileged or irrelevant. There's a few other ways to do it. So if it's relevant and it's not privileged, I get to get it in front of the court. The next assertion here is NRS 217.464 subsection 2, which states that this court can inquire independently into the issuance of my ex's fictitious address and the best interest of the child doctrine. And then there's another law, which is NRS 125.480, which allows the court to inquire independently into CPS reports. So I'm not sure how much more statutes I can throw in this judge's face, but it worked because at the hearing I won and the judge did look into all these details. If I didn't do this, would the judge have looked into the details? Most likely no. Most likely the judge would have said, hey, CPS already looked at it and they said there's nothing there. That's what would have happened. The judge would have not wanted to look into it. Case closed, you lost. When when your opponent tries to do this to you, you have to hit them hard on res judicata principles, specifically issue preclusion. If your opponent cannot show that issue preclusion applies, your opponent loses, and you can bring CPS reports and all that stuff into your child custody case. I highly recommend doing this because of what I talk about in the video, abuse and neglect proceedings. Going into the next assertion here. My ex willingly refused to attend the child's dental appointments. It's not that I didn't give sufficient notice or capitalize on my ex's work situation. It's that she's under order to schedule appointments and provide me with 14 days notice, and she didn't do so. Now, I do go into some details here where she tried it in the beginning, and then, of course, we had the aborted first procedure, and then we go into the second procedure, which she said she was going to pay for, but then stated she didn't want to pay for and all that stuff. We talked about this a number of times, so I'm going to skip over this gigantic section here. Moving into the next assertion, which is that my ex contends that I gave her no notice of the address, phone number for the place of surgery, or the time of the dental surgery. The parties consulted with Wyatt Smith and they were notified about the dental surgery, including the date, including the location, including the pre-op appointment, all of this stuff. She was there in person. So she's basically saying, and again, this is just dizzyingly idiotic. She's basically saying that even though she was there in the room with me and the advisor, and she was told all of these details, somehow I needed to intuit psychically that she needed me to also tell her, again, all of the same things that Wyatt Smith had already told her to her face. This is the crazy type of stuff that not only my ex, but even her attorney shoehorned into her opposition. I don't understand if they're not thinking these things through, or if they just think that the court is just going to get so distracted and busy that they're not going to pay attention to any of the details. It could be either one, because both of them are very likely. Let's go on to the next section here. My ex's contention that she has also worked with me to meet her share of the dental surgery is laughable. She filed all of these motions, all of these orders were entered. She went behind my back to Leah Shevler and tried to have me excluded from attending the child's dental appointments. That's lovely. The dental hygienist documented the aforementioned incident and will appear in court to testify that I didn't even remember this, guys. This is the kind of stuff that's infuriating. All of that work just for her to say, hey, I'm not going to pay. And then it's not good enough. She actually has to go behind my back and try to get this hygienist to not allow me to go either. I don't understand. If they put this much effort into actually loving and caring for the child, it would just be, it's just mind-boggling that they put so much work into getting in the way of everything. A lot of people think that these are neglectful parents. They just don't care. They're not responsible. It's like, hold on a second. This is not somebody who's just kicking back, going out partying with their friends, sleeping in all day. This is not a person who doesn't care. This is a person who cares very much to actually deliberately and intentionally inflict damage. This is a person who is very cognizant of what she's doing. It's like she's made a list of things to do. It's not that she doesn't want to be involved, and it's that she does want to be involved, and that she wants to take every step that she possibly can to ruin him, not just like mentally and emotionally, but even physically. That's where we go into with the dental damage. Going into the next assertion here, ripeness of modification based upon relocation, and I think I just counteract my ex's assertions. I know that there is a case that allows you to get an order granting relocation specific, or that triggers off a specific event. There's not a whole lot of authority in here. I wonder if I cite it. Well, I'm trying to use Cunningham v. State against my ex. Maybe that's because she hasn't cited any statutes or authority that says what she's saying is true. That could be why. So it looks like my ex raised the fact that the court was not allowed to allow me to relocate based on a triggered event. And I'm asserting that she's failed to cite any authority that supports that assertion. So, I mean, maybe I did well enough in the motion that I felt this is all I had to do on reply. Next, we have the conclusion, which is just a standard boilerplate conclusion that says, for all the reasons stated above, please allow the hearing to proceed and let's modify custody. Here we have a declaration in support of the reply, and this is swearing under penalty of perjury that all the facts alleged in the reply are true and correct. Here we have the Rule 5 Certificate of Service indicating that I mailed this document to my, well, did I mail it? No, I personally served this document upon my ex's attorney. Next assertion, or next page, is 9 different exhibits. It looks like all of these may be new. If they're not new, guys, I'm going to skip over them, as I always do. If I skip over any documents because I've already gone over it in my Docket series, all you got to do, if you want to see it, is go down into the description below, click on the link, and download it. Here we have Exhibit 1. Looks like my ex is saying that our son's appointment got moved to November 2nd at 3. Exhibit 2, which is that there's another dental appointment scheduled that's been reserved for our son. Here we have Exhibit 3, which is the dentistry for kids. Is this the first or the second one? I can't tell. In any event, this is me giving an email to my ex to let her know about the date and time of the surgery, or just the appointment maybe. So 3 emails where I'm showing my ex dates and times and locations. Here we have a Dr. McKenzie. Okay, so this is the appointment with the general physician. This is the pre-op appointment that was required. So I'm giving her those details there. Exhibit 5, here we have me saying, hey, you haven't responded, so I'm going to just schedule everything on my own. And I just go ahead and explain why the pre-op is needed and all those details there. I think she was just hoping that I wouldn't do anything and that it would all go away because she didn't want it to happen. Okay, Exhibit 6, here we have the Time came in an hour ago. Okay, yeah, so my ex was saying, hey, you didn't give me the time. And I'm responding, hey, I didn't have the time until about an hour ago. Here you go. So I give her the time. Exhibit 7, we have the account history report. This is probably just the billing. Probably, this is all of the damage that our son had to get fixed. Anyway, wait, what is this? Interesting. Hold on a second. These are notes from the hygienist. So my ex does not want to do TX under GA due to something. I want to know why insurance doesn't cover dental work. Here she's saying that we were fighting at the beginning of the appointment, and then my ex doesn't want me to be involved. So there is nothing here really. Okay, I'm going to continue to read through this. Hospital setting under general anesthesia. Per my ex, our son is traumatized due to a previous dentist hurting him. What? Per my ex, he does not like to be surprised. The doctor explained that the doctor never tells the kids that they will numb due to their reaction. He will numb due to reaction. Either way, child will have a horrible experience. If the procedure is done in the office, the doctor stressed the importance of doing it under general anesthesia because of the past experience. My ex did state that if general anesthesia is recommended, she'd have to save up for it due to something. Let her know that they will try again with the insurance company. If they refuse, give us a call. Okay, so it looks like she was having some communications over the phone with these people that I didn't know about. Anyway, let's move on to Exhibit 8. We got the attendance issue, and we got 14 excused absences. And now these are the absences that she's reporting to the school. So if you remember the first time I tried to modify, she just wouldn't report them and they become an excuse. And so these 14 were, what I'm asserting is she lied all 14 times. And this comes up in court, so you don't have to take my word for it. She's going to be questioned on the stand, and the court is going to side with me, and the court's going to make a finding of fact that these absences were damaging to our son. And you can see here that most of them are her by quite a while. All I have is a couple of tardies down here. Actually, all I have is tardies. I don't have a single absence. No, we have one absence, and that's the actual surgery. That's when he went to the surgery. Okay, so 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 absences by my ex and 3 tardies from me. Oh no, there's more. 11, 12, 13 absences. So we already know it's up top. It says 14. Let's continue on. Exhibit 9, you have the account history report. So it looks like some more discussion here. This is when she was doing the red coat tests. So I've talked about all this before, and this was used to modify physical custody. I think this is everything. Let's go on to the next document. Request for submission. Everyone who has seen this channel has probably seen about 50 of these by now. If you want to know more about the request for submission, please watch the video, Request for Submission. I explain it in detail. And then the last page is the Rule 5 Certificate of Service indicating that I personally served this document upon my ex's attorney. Going into the aftermath, I filed one document and... No, I filed both. I filed 2 documents. Those were free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, my standard policy with replies is they probably don't put much time into them because they don't have to do anything in response. They do have to read them because it does give them insight as to what may come up at a hearing, but still, it's not a lot of time that I think goes into reviewing a reply, as much at least as to reviewing the motion, because it's going to lead to the opposition. So I think under these circumstances, maybe 15 minutes to read that reply. There were some emails. So you know what, let's bump it up to 30 minutes because she's going to have to review the emails. And of course, we'll just lump the request for submission into that 30 minutes. So 30 minutes at the rate of $250 an hour is going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.